Well, ladies and gentlemen, how's everybody doing? Sit back, relax, watch the clock. Got a little minute to go, and we will be coming back starting the show. We will be talking about some prosecutorial issues today. Families yet looking for justice. So sit back, relax. We will be coming back to you, okay? Excuse me. I want to say welcome, ladies and gentlemen, to the Tony Hollis Live Talk Show Testify. We got a real good show for you all today. Just sit back, relax. I just want to say before I get started, first of all, it's been a long break for me. I appreciate you all waiting to I resume uh, my talk show. Um, and many of you know that been doing a lot of things. Been sick as well, and but I'm back in the driver's seat. But anyway, before I get started, I want to go ahead and show you all. I think we got some. Let me find it here. We got some voting issues that's going on. I want to say you need to be very uh, um, aware of these bills here. You have one bill that's here in the state of Arkansas, 1112, it's a provision ballot. There's a lot of changes that is has is taking place as I speak in regards to the provision ballot. There used to be a point in time to where you can vote right there on the spot. If there was any problems with your information or what have you, you still was allowed to vote. That, to my understanding, has come to an end. Um, there are some rules as to what the voter should do. Shall this be the case? You also have another bill, House Bill 1244, voter ID. You have another bill that's in the Senate. This is Arkansas State Senate now, Senate Bill 12 regarding absentee voting, uh, as well as there's another bill, Senate Bill 217, absentee voting. I would like to say to all the candidates, to all the chairpersons um, who's running the campaign or whatever, you might want to get with your people early to get this information out, educate them on these laws. Let's be ready. Uh, Therefore, when election day come, you will be ready and good to go. Today, we're going to be picking back up on talking about some cases to where there has not been any closure for people who have either lost loved ones to violence, that it be at the hands of the police department or that it be at the hands of citizens. And so I had four people scheduled to come on when I start my show back up, but unfortunately, I only have one today. Okay. Um, the guest that I have today, I'm going to let her tell her story. Um, fortunately, her son is alive, although he did face violence, to which this family is still waiting for justice, uh, for their loved one. But anyway, I'm going to go ahead and bring on my guest. How you doing there, Miss Marsha, Miss Davis? I'm going to go ahead and bring on my guest, excuse me, and let her introduce herself. She's from the Jonesboro, around the Jonesboro area. Met this nice lady during the campaign run. We had many conversations, although we haven't really met, but we have shared quite a few messages, whether it's email, whether it's text messages, and phone calls as well. But anyway, this is a lady, like I say, she's a very nice, lovely lady. Um, Violence struck in her home, and she is yet trying to uh, get justice for her loved one. And so we're going to go ahead and bring on my guest right now and let her go ahead and introduce and tell a little bit about herself. All right, so let's add her now. How you doing there, Miss Anita Wells?
Hello, Tony. Thank you very much for having me tonight.
I'm glad to have you. Glad that you uh, sort of uh, took me up on this last minute offer. I want to say to my guests, I don't know what is that popping, crackling sound. I don't know if it's my speakers or what, but it appears to happen only when I speak. So I ask that you all just disregard the technical issues that we have, and we will try to make this as smooth as possible as we move through this broadcast. But Miss Wells, I just want you to just briefly go ahead and tell a little bit about who you are, and after give a little brief background of what happened to your loved one as it relates to violence.
Okay, I'd be glad to do that. I am Anita Wells, and I live in Paragould, Arkansas. And I grew up in Wheatley, Central Arkansas, and I moved here after college for work. And so I've been in Paragould ever since 1980. So I've been here a long time.
Uh-huh.
And did you say something, Tony?
No, go ahead.
Okay. All right. And I moved here to work and raised a family. I work in X-ray, and I'm also a psychologist here in Paragould, community minded, involved in the community. My husband and I have 2 grown sons. And the case that Tony and I have been talking about, my son was shot on March 13th in 2014. So it's been 7 years.
Uh-huh.
And uh, 29 months after the shooting, prosecutor Scott Ellington dropped the charges and on the defendant. And so I'm still looking for justice 7 years later.
So it's been 7 years. I tell you what, before we move any further, I want to go ahead and play this video of Mr. Ellington, pretty much trying to give reasons as to why he's the better candidate, which the seat that he now occupy of circuit judge now. He used to be the district prosecutor for, this this division, this district, excuse me. But let me go ahead and play this video to where he's sort of somewhat explaining as to why he dropped the charges against your son. So let's go ahead and find that video now. Now, I don't know if you heard that clearly, but he was trying to give reasons as to why he didn't prosecute the person who shot your son is because his reason is that it was on the suspect or the shooter. It was on his property. So you heard that from Mr. Ellington. How do you feel about the statement that he made as reason as to why he didn't bring charges against the man that shot your son is because it was on the defendant, the man, it was on his property. How do you feel about that?
Well, I'd like to get a little bit more background about the case of what happened the night of the shooting. My son was at my other son's house having dinner, and with their girlfriends, or well, friends. We were females, and the defendant was texting one of the girls and belittling her and talking really ugly on text. And so my son got involved, and the defendant said, "Come over and I'll whoop your A." And so my son said, "Sounds good." And so he was invited over there. And in my opinion, if he didn't want my son at his house, he should have said, "Don't come over to my house." So he invited my son over, and when my son got there, the defendant came out with a gun and met my son near the road. Now, it was on his property, but it was very near the road.
So if I understand you correctly, there was some type of text messaging going on between your son and the defendant, the guy that shot your son. in terms of words being exchanged to where he invited your son to come to his home, I guess, for some type of altercation?
Well, for a fight, uh, invite him over for a fight, not a gunfight, but a
Okay.
fist fight. And so back to Prosecutor Ellington, in a article, he was in a previous article, he was quoted as saying, if you invited someone into your home, then it's different, Ellington said. We would have to look at all the facts and make a decision then because you invited them in. So, it's very different whenever you invite someone over.
Well, so, and this case was pending for how long?
What's that, Tony?
I was asking, this case has been pending for how long?
Oh, well, he 29 months after the shooting was March 13th of 2014, and 29 months later, the charges were dropped, so the case is closed.
So, the case had been pending for at least over 2 years before they dropped it.
That's right. That's right. We're waiting
Okay.
for.
And I also want to put some up on the screen. You pretty much already done explained it, but one of the things that um, Mr. Scott Elton talked about. Let me see if I can find that letter. I want to show this letter. Let me go up here and find it. Uh, Let me go up here and find this letter. Uh, Give me 1 minute. Go up here and find this letter. Okay. Now this is a letter here. I don't know if you can see that. Uh, you can see that, correct?
I can see what you have on there. Yes.
Okay. Well, this letter right here is the letter. It was dated the 21st of September, 2016. This cause came on to be heard. The plaintiff appearing by Scott Ellerton, prosecuting attorney for Craighead County, Arkansas, within the defendant is charged with the offense of battery. It being sworn to this court that it is in the best interest of the parties that this offense be noli prossed, which means just non-process charge, dismiss it. Whereupon the state moved that the above charge be non-processed, and he attested an exhibit. Now, I want to go and show this letter. I sort of get it marked D being the defendant and V meaning the victim, your son. I want you to pay close attention to this second paragraph where I'm waving my cursor. Mr. Ellerton, in his letter to the chief of police, I guess he gave him notice that his prosecutor, Mr. Fickenbeiner, has not shown a hesitant to move forward on difficult cases. He goes on to say that this prosecutor, Mr. Finkenbeiner, he took a very difficult child battery case to trial. The outcome was questionable until the jury returned with a verdict guilty. And it goes on to say that uh, Mr. Fickenberry, the prosecutor who was handling your son's case, in so many words, he didn't drop your son. He didn't ask for your son's case to be dismissed because he feared losing, but rather a question of what justice is in this case. And it goes on to say, let me find it. He gives reasons as to dropping these charges, and here are the 6 reasons that he gave. The very first one is the victim, which is your son. He admitted to my deputy prosecutor that he didn't know what or how much he drank that night but apparently he felt compelled to have a sober driver. Number two, witnesses who rode to defendant's residence with victim said he jumped it out of the pickup truck and headed toward the house as soon as it stopped it rolling when they arrived at defendant's residence. Three, victim was on defendant's property in the front yard when defendant shot him. Four, an eyewitness states that he saw the brother of the victim immediately get out of the pickup with what he thought was a baseball bat, which turned out to be a Remington 30-60 rifle, which he fired twice during the incident at Mr. The defendant's home. Five, victim was shot in the back, your son, shot in the back in his right shoulder area, and the bullet traveled downward and exit through a lower point on his back. At 6 feet tall and 245 pounds, victim, your son, was 2 inches taller and 45 pounds heavier than defendant. Defendant says that as victim approached him, he attempted to strike victim on the head with his right hand, the hand holding the pistol. And as he made contact, the gun accidentally fired because the wound entered from the top of the victim's back, traveled downward, and exited in the middle area of his back. Defendant explanation seemed likely. If defendant had set out to shoot, he more than likely would have shot him point blank with the bullet entering his front and exiting out of his back. Last point, finally, when the content of victim pickup truck, your son, was inspected, paragroup officers found the rifle, a 12 gauge shotgun, and a pair of brass knuckles. And so, according to this law, for those of you who are saying we never had a stand your ground law, we did. This is self defense bill. That's the code there, 52607. It actually states that a person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is about to commit a felony involving force or violence. The statute further provides a person may not use deadly force. And this is what I liked so much about the last bill that we somewhat abandoned. Uh, it say a person may not use deadly force in self-defense if the person knows that he or she can avoid the necessity of using deadly physical force with complete safety by retreating. He goes on to say, but in this particular case, uh, a person is not required to retreat if the person is in the person dwelling or in the curtilage surrounding the person dwelling and was not the original aggressor. And it goes on to say, in so many words, and I'm gonna close out on this here. It say, this is Scott Elton. I think a jury would struggle with finding justice due to the fact of this case. I myself struggle to find justice in prosecuting an individual who was engaged by one or three adult males on his own property, especially when those three individuals had two long guns and a set of brass knuckles with them. It is apparent that his brother and the other individual came looking for a fight at defendant's home, and they found one. After further consideration, our office will withdraw prosecution of this matter and close the file. Now, that was uh, what Mr. Ellerton, pretty much closed out on. So there it is. That's the letter that he wrote to the chief. I forgot what city they were. I think it was Paragraph. Uh, indicating as to just putting him on notice that they were dismissing uh, the crime that was committed by against your son. Uh, is that your first time seeing that letter I just read?
No, I saw it back then. I received an email with that letter that letter in it the same time that he sent it to,
Yeah.
at the
So,
time he sent it to the police chief. I was
is
just
there any
reading the
truth to
letter.
that letter?
I disagreed with every point that he made, and I'd like to give one good example. He said that the bullet entered his upper back and came out his lower back. The bullet entered the front of his neck right here, and it came out at his upper scapula area in the back. So it went in the front and came out the back, upper back. But he said in the letter that it went in the upper back and came out the lower back.
So,
That's
in other words,
blatantly wrong. That's just wrong.
prosecutor, Mr. Scott Ellerton, he took off his attorney hat and he became an expert when it comes to ballistics, in terms of forensics, studying how, in this particular case, the bullet, how it penetrated the skin and what direction it took once it entered the body. Um, I would think that a judge probably would have not accepted, his reasoning in terms of he passed himself off as an expert. I mean, that's what I would think. I mean, how do you and your son feel about that? I mean, it's almost as Mr. Scott Ellerton, he sort of went the extra mile to make sure that this case was dismissed.
Right. I agree with that. And there's a reason that he dismissed that case. I don't have a finger on that. I would love to know the real reason. Personally, I think that it may be politically motivated, or just their direction of duty, non-feasance, misfeasance.
Yeah. I understand also that,
I don't know.
yeah. Well, Mr. Scott Ellerton is a circuit judge now, so he's not the person that you will be dealing with now. There's a new prosecutor, Keith, got his last name. I'm sure you know it because to my understanding, you now is working with the new prosecutor to try to somewhat get this case back open.
Yes, Prosecutor Ellington left his position as prosecutor and was sworn in the circuit judge January 1st, so a couple of months ago. And now a new prosecutor has been appointed by the governor. His name is Keith Cressman. And so he will complete the 2 years that Scott Ellington still had on his prosecutor position. So I've reached out to Keith Cressman, sent my information, and with a letter stating that I disagreed with every point that Scott Ellington made in dismissing this case, and I'd ask him if his office to review the case and make a decision on that.
Well, do you seem pretty hopeful now that we have a new prosecutor? Do you feel pretty hopeful that in your particular case that maybe this new prosecutor will take a second look at your son's case?
I'm in hopes that he will. I think that he is an honorable person, and I would hope that he would review it and consider or reconsider or make some changes to Scott Ellington's decision, because, like I said, I think that it was blatant. The information that he used was so wrong to dismiss that case, and that's what I put in my letter to Mr. Cressman. Blatantly incorrect information.
Well, it appears to me that in the letter that I read, on the court docket, it don't really show that this guy, the defendant, it wasn't like there was a not guilty verdict. What they did, they non-processed this case. From what I understand about it, there's a Latin term they use, no live prosequi or whatever they call it. Same thing, meaning they non-processed in the case. In other words, they have abandoned the case. But to my understanding, whenever a case is non-processed, that case, charges can be refiled. So when Mr. Ellerton say that the case is closed, uh, it's sort of like, he's mixing apples with oranges there. I wouldn't say the case is closed. The case, when you non-process a case, is almost like there's not enough evidence to go forward with this case at this time, but the case can be filed again. I mean, that's my understanding. But when you hear Mr. Ellerton in his letter stated that the case is, the case is closed or the file is closed or whatever, it appears to me that he have no intention of refiling these charges. Well, he's a judge now, but he never had any intention of refiling these charges. It wasn't like this young man was found not guilty. So how do you feel about that?
Right. And
Pardon me?
well, it appears that Scott decided that he was not guilty. And because, he even said in the letter that my son or the girl should have let the court system take care of the grievances. And, I'm waiting 7 years and the system has not taken care of the grievances. And I've been working on this for all 7 years. And if you don't mind, I'd like to tell you a little bit more history.
Go ahead.
Because in this letter that I sent to Mr. Pressman, it states that the defendant is a menace or a threat to society and a danger. It could be a danger. He had been arrested 5 times in 5 years. He was on misdemeanor probation when he shot my son, and they did not revoke his probation. And I asked why, and they said, well, because he got more serious charges. But then those charges were dropped, so then nothing was done. And since he shot my son, a year later, beat up a guy, put an AK-47 to his head, and told him to beg for his life. And then since then, restraining orders have been put against him by his fiancee. And then later, a whole other recent incident, his mom and a general manager at the workplace filed a restraining order. And so those were dropped. However, that just tells you there was a reason that they were filed in the first place. And so, there is a threat there. There is a danger there. And he has a significant history and a pattern of violent behavior.
So if I understand you correctly, that this man who shot your son, he already has a history of committing criminal acts. Now, let's just say that. And let me ask you this here. What do you know about this man? Why is he getting off so? Is he connected to your belief? Is he connected with someone? It just seemed like to me with a criminal history like that. And I think you indicated that he recently just come from court. So why do you think he keep getting a slap on the wrist?
I don't know.
I'm not asking for you to guess, but
I know that's a good question. That's a good question for all of Second Judicial District to ask themselves. And I have been all over Second Judicial District, and I've run into people with similar cases. They've been dropped. They don't have justice taken care of. So there's a pattern here, and it's time for people to realize that. And justice is not being done in a lot of different cases, and it's not just my case. It's a lot of other people who are hurting too that haven't gotten justice.
Oh yes, you and I talked about that. So, Mrs. Wells, let me ask you this here. I know you didn't send a letter to the new prosecutor. How long has that been? Has it been just recently, or has it been months, or what?
He just took that position in January, so it was probably February, March. I don't have the date on that letter.
Also, it
So
really hadn't been a whole lot of
recently,
time.
however, right, it
Hmm.
hasn't been long. And I will say this: the defendant does have an upcoming court date here in April in just a few weeks, and so I'll be curious to see what happens for that case. You know, are we going to see a pattern, continue the pattern, or something to be done for recent violations?
Well, okay, Mrs. Wells, like I said, I wanted you to come on and tell your story. And before I close out, uh, I want to give you every opportunity to share as much information as you possibly can. Is there, I know you just mentioned, share with us about the criminal history of this young man. You say he's actually a danger to yet be on the streets, free man. Um, is there any thing else you would like to share with the public uh, in regards to some things that you are doing, or even things as it relates to this uh, gentleman that you is trying to bring to justice? I mean, is there anything else you like to share?
I really think that Scott Ellington is the key to my problem and a key to a lot of other people's problems. Whether it's incompetence, is he incompetent? If he is, then he does not need to be did not need to be elected to circuit judge. So that's something that people need to be aware of. They need to know that he will be up for election in 6 years. Does he actually need to be a circuit judge? I'd love to know who voted for him this past time. I would like for people to look at their get their information, be informed voters, and when they do
Uh-huh.
vote in 6 years with Scott Ellington, because I think he's a key part of a lot of our problems.
Well, Mrs. Wells, I know you and I have been talking for a while now, and not just the political stuff, but we've been talking about things as it relates to the criminal justice system. Um, and you had alluded to Mr. Ellington. Uh, he's in his beginning first year of 6 years serving as circuit judge, correct? And in 6 years, he'll be up for re-election. Um, and if I heard you correctly, uh, if Mr. Ellington uh, didn't satisfy you in regards to, as it relates to the violence that your son endured, and Mr. Ellington was a district attorney. Uh, so if I read you correctly, you don't feel that he is deserving to serve another 6 years as circuit judge.
I definitely do not think that because I think it's a mixture of incompetence and uh, misfeasance or dereliction of duty. There's just too many cases, and we're going to be hearing more and more about these cases because I don't plan to stop, and I'm meeting people every day who have similar concerns, and so I, for one, think that people need to think seriously about maybe someone else wants to be a circuit judge besides Scott Ellington.
Well, I will say that I sort of agree with you wholeheartedly when it comes to Mr. Ellington in terms of his record serving as district prosecutor. Right here in Blythe, Arkansas, we have had 2 or 3 cases, either where there was no charges filed uh, against. Uh, I think all of these cases that I'm speaking of, I think 2 of them resulted in death, and 1 of them resulted in an injury. It might have been 2, but we had a young man um, who was. The verdict is still out in terms of how he died, but he died while in the physical custody of the Blythe Police Department. No charges was filed by uh, Mr. Ellison uh, office. We also had a uh, young man. I think everyone remember the young man down at the Dodger store to where uh, he was shot and killed. Uh, no charges filed. There was a young kid at a juvenile facility in Marion, Arkansas, was shot and killed. No charges filed. There was a young man again here in the first case here in Blytheville. Young man got shot in the back in front of his mom. No charges filed. So Mr. Ellerton have a record of either dismissing charges or not filing charges when myself and the public believe that the cases that I just mentioned, um, I just find it hard to believe that there was not one um, charge that was filed in the four cases that I just named. Now down in Marion, Arkansas, I don't know if he had that one or what, but here in Blytheville, we got three cases here in Blytheville, and one was in Osceola, of course, the young kid that got shot in the back out there at the gas station. And so I do pretty much understand and feel where you're coming from when you get second thoughts about we having people to serve in a judgeship position when we didn't get any justice when they were serving in a prosecutor position. And so I understand you wholeheartedly. Um, but hopefully we can probably come back and I think you indicated that you had a book out that you wrote or something. You want to talk about your book?
Yes, I compiled. It's really a document, but I call it a book. It's
Hmm.
about what really happened because once he closed the case, it looks like that we can some type of agreement on what happened. However, like I said, in this book, have rebuttals. I disagree with every point that Scott Ellington made. And so it's really a document. I don't know if maybe I can hold it up where you can see.
I can see it.
And injustice, millimeter for murder.
Right.
And I have plenty available if anyone's interested. If Tony, if they want to get hold of you, I'll be
Okay.
glad to mail my book to them.
I will be getting back in touch
Book,
with you,
whatever it takes.
and I would get the information, and I would certainly go ahead and next show that I run, I will put your book on the screen, and hopefully document Terry, I think what you indicated it was. Uh, and so I would definitely go ahead and put that on the screen, and hopefully, we'll have those out there in the community that will take interest and, either purchase or a copy of your documentary. So Ms. Wells, has been well spent. Like I say, I want you to use every opportunity of this time that you have now. If there's anything else that you need to bring forth, I'm extending again this time to you. If not, I'm going to go ahead and close out with final remarks.
Okay, that's fine, Tony.
Pardon me? I didn't hear you.
One thing I would like, one thing I would like to say is I don't think I let people know that my son, the shooting, it hit in his neck and thoracic 1, 2, and 3, and it hit his spinal cord. So he has a spinal cord injury. So he's disabled permanently, and so that's a lifelong. If Scott Ellington found him guilty, then he has his lifelong sentence where the defendant got nothing. And so it's very unequal.
And I want to apologize for that. Um, I meant to ask, how was your son doing now, both physically and both mentally? But you explained from a physical perspective, uh, your son right now suffers from some disability, physical disability.
He has that spinal cord injury, so his gait, his walking is really difficult for him. Pain all the time,
Mhm.
difficulty just getting comfortable. And he's an avid hunter and fisherman, loves the outdoors. That's the reason that the guns were in his truck that night. They had been out. It was cold, cold, cold. snowing and sleeting. It was frozen that day. They had been out shooting their guns, whatever.
Mhm.
That's just what they do. And the guns were in the truck. And so um, he's not able to do that hunting and fishing anymore. He cannot do that. So how would that make any person feel?
Mhm.
It's a long life of not being able to do what you enjoy doing.
Okay, you just spoke about his physical disability. Is there any is there any psychological challenges that he have? In terms of him facing the barrel of that gun that particular night. I mean, is there any psychological challenges that he have now as it relates to this incident that he endured?
Uh, well, psychological because of the actual shooting. However, the side effects, like the depression, anxiety, a lot of that is associated with nerve damage,
Mhm.
and just have to live a painful life is depressing for anyone. And a second whammy, I'll call it, because he was really fighting because he had to relearn to walk. He had to relearn to walk twice, and and then whenever Scott Ellington dropped charges, well, then that's like, who cares that I even got shot?
Mhm.
That,
Well, let me ask you this
who,
here:
who even,
have the family thought about bringing some type of civil action?
you have a year. You have a year to do a purposeful, intentional civil suit. You have that first year, and so that year passed before, and during that first year, the local prosecutors were all about uh, filing the battery charges and going full force, getting restitution for health cost and medical cost, and so they were all for that. And so it looked like it was going fine until 13 months, and 13 months is after that year.
Hmm.
That's when he moved. Ellington moved the case from Perryville or Greene County to Craighead County and gave it to Charles Finkenbinder. So it was too late. You can't do that. And see, our local prosecutors, we believed them when they said we are going to prosecute this to the fullest extent of the law. We believed them when they said that.
Hmm.
And then he traded it off. And so then you have 3 or 4 years for negligent. We don't think it was negligent. You don't file a civil case if you don't think it's negligent. That's, you'd be agreeing that it was just so you can get money. We didn't want money. We wanted justice.
I totally agree. I totally agree. I mean, from just a physical aspect part of it, what your son is dealing with day to day, and I imagine there's no reversing in his physical disability. He pretty much gonna be that way for all his days on life, huh? Hmm. Well, I'm sorry to hear that, and like I say, let's stay in touch and let's continue to go ahead and dialogue, if you will, any information that I come across that I believe that will serve you, in your pursuit of justice. I will reach out to you, Mrs. Wells.
Thank you, Tony. I'll be glad to do that.
Well, okay. Well,
Thank
we're
you
gonna
very
go
much.
ahead and end this segment, this podcast. I don't want you to be a stranger. Whenever you feel like there's some information that you want to put out, give me a call. This is the People's Platform, one place that they can come uh, to testify. And I thank you for coming, sharing with us today, testifying as to what you and your family went through.
Thank you very much.
All right, then. So until then, I say I'll see you when I see you, which will be soon because we're in an election year now. And so I will be reaching out to you. Hopefully, you'll run for office. Yeah.
I
All
will
right,
do
Miss
that.
Wells, you take care. Pardon me?
Thank you.
Yeah.
So thank you very much.
Yeah. All right. All right. Bye bye. Well, that was Mrs. Wells from Jonesboro, Arkansas. Uh, she she come on to tell of her ordeal. You all, we got a lot of cases that continue to be either dismissed for whatever reason, or in other cases, there are not even any charges being filed against those who uh, commit violence against another person. Um, in this particular case, Mrs. Wales' son, um, the prosecuting attorney, Mr. Ellerton, in so many words, number one, his prosecutor didn't, he had thoughts about whether or not he could win the case, considering they believe that Mrs. Wales' son, according to them, that he sort of contributed to his own physical injuries. Um, but and then they used the stand your ground law. I think Mrs. Someone asked me what was that statute again. The statute is 5 uh, dash 2 dash 607. Let me see if I can put this up there for you. Um, but that's the statute that Mr. Ellerton was using to justify that no charges should be filed against the young man that I say young man, the man that shot Mrs. Wells' uh, son. Uh, but this is the statute right here. Uh, that's the This is the Arkansas statute. Let me find it. That's it right there. For those who asked the question, what was the statute? That is the old statute now. Okay, remember we just recently passed a stand your ground bill. Now this statute that you're seeing right now, 5 dash 2 dash 607, that statute was considered what is called the castle doctrine. In other words, when someone invade your home is your castle, okay? When someone invades your home, you have a right to shoot and kill them dead. The only thing that the legislators and others didn't like about this statute, 52607, what they didn't like about this statute, it said that if the person who is faced with harm, if they see that there is a way for them to escape or retreat in a safe manner, then the law specifically state that that is what the person should do. You just don't shoot and kill somebody because now you got a weapon, you got the upper hand on them, and you can shoot and kill them dead. This what was good about this particular law. It had that little clause in there to where if the person who's being threatened, if the person see that there is a way for him or her to retreat in a safe manner, then the law directs you to do that. Now with this stand your ground bill, that law has been removed, or that part of the self-defense bill has been removed. Now it's up to you, the person, to decide that if you reasonably believe that you are in danger, then not the judge, not the jury, not the police department. The decision is left with the person who believes that they are in what they call imminent danger, and they have a right to make a decision to take that person's life. So that's where we're at now with the stand your ground law. As Mr. Ellerton indicated, he said that one of the things that reason that he dismissed this case was because it was on the shooter's property. We have a case right now. I'm not going to call this young person's name. We have a case right now in Oak Hill, Arkansas. A case right now to where a young lady, 19 years old, has been charged with a felony. Why? It's because she was fighting on her property. In so many words, she didn't have a right to stand her ground. She's charged with a felony. Be in court this week, this coming week. So Is the stand your ground law, is it for some people and some people it's not? Because if we're going to be fair about this stand your ground law, it has to be equally unbiased, without any type of racial reasoning behind as to who you apply this stand your ground bill to and who you don't. So hopefully this young person in Osceola, uh, hopefully this young person, uh, they will rethink about prosecuting this young person, 19 years old. They trying to destroy this person's young lady's life, 19 years old. And she was fighting on her property. But, and I'm closing on this point, but what I don't like about this particular case that happened in Osceola, and it's not just her. I don't think even the people that she was fighting with, I don't think any of them should have been assessed with felonies. It was a fist fight. No weapons, no guns, no knives, no bats. It was a fist fight. If that the case, back in my day, we all would have been hauled in the court for felonies because we fought with our fists. We got to watch this case. These young people should not be faced with felony charges. None of them. It was a fist fight. But you know what the police department is calling it down in Osceola? You get a bunch of black kids together and they up to no good, and a fight break out. You want to call it gang related. Gang related. Gang activity. To where now you can assess a felony against these young people. You all, if you are lovers of our youth, supporters of our youth, and more importantly, parents of our youth, then you will take it upon yourself to inject yourself not just into this conversation, but you need to do something. Take some action to let the criminal justice system know that we are tired of you criminalizing our youth. It's even in our schools, and you all know it. They call it the schoolhouse to the jailhouse pipeline. It used to be a day and time in the schools where they would resolve those matters with the teacher, probably with the principal, and the parents come up and they sit down and they worked out a reasonable resolution as to how they was going to discipline students with behavior problems. They didn't call the police. They didn't call the police back on children back in my day. Those were matters that were handled in the school system. And that's the way it should be today. They criminalizing our youth before they can even graduate from high school. So what does that mean? They got no skills. They've been in juvenile hall. They come back to school. Now they're being labeled. It has to stop, you all. These young people down in Osceola, 19 years old, and they facing felony charges for a fist fight. Person didn't have a right to stand her ground on her own property. But here it is. You heard today from Miss Wells. The shooter shot her son in the back. Charges dropped, dismissed, file closed. Why? It's because it happened on his property. The law is not evenly applied. Anyway, that's all I have, you all. Hopefully we'll get the other three women on and let them use the opportunity to share their story with you all in regards to uh, they are yet in the pursuit of justice for their loved ones, um, whether they lost them through death or whether they lost them through some physical injury. They are yet seeking justice, and hopefully, they'll find that justice to where they can have some closure. That's all I have. My next show will be Sunday at 6 o'clock p.m. I don't really have the topic. If I can get these next three women to come together, hopefully we'll run that show next Sunday as well. Families who yet in the pursuit of justice. Uh, so let me run over here to my screen. I don't want to close out until, in case someone have a question over here. I'm searching for questions. I say hello to everyone. Uh, but I don't see any questions. That was my cousin Shayla said she couldn't see it. I thought I had it blowed up uh, as much as I could for the Zoom. That's why I took the opportunity to read it. Uh, Mrs. New, I think, did she have a question subject to the statute? I think she made a statement as it relates to the law. She said something, what is that? I think it's still subject to the statute of limitation. I think Mrs. Wells alluded to that. I think she said the statute of ran. I still would suggest that she speak to an attorney before she decided to go ahead and close out on that. What was that? What was that statute? Okay, I gave you that statute number. Pretty sure I put it up again in case you didn't see it. Where's that statute I just wrote? Where is that statue? I just had it. Oh, let me see. Where is that statue? Well, I'll go back and find it later. But anyway, oh, there you go, right there, isn't it? Y'all gotta excuse me. I got my eyes is a little watery here, and I'm not seeing too good. But anyway, hello to everyone. Hello to everyone. It's a 3 year. What is that? It's 3 years from the date of the incident, unless her son was a minor. Then it's 3 years from 18. You are correct. I don't know exactly how. I think her son is an adult, but still, it's a 3 year window, I believe. If she decided to go ahead and bring some type of civil action against the man who shot her son. But again, that's the statute right there, 5-2-607. Understand, this statute here is the old self-defense statute that we had, which has been replaced by the new statute as we know it today. Is called the Stand Your Ground Bill. But this is the law that Mr. Ellerton used it in his exhibit, explaining as to why no charges should be brought against the person who shot Mrs. Wells' son. Look like that's it, you all. I want to say I thank you all for sitting with us. Time been well spent. And hopefully you'll come back and visit with me next week. So I want to thank you all for taking time out your busy schedule again. Okay. So we're going to go ahead and close this thing out. And I like to say, may you all have a blessed and peaceful night. Okay. Peace and love. Remember, the pandemic is real. Still wear your mask regardless of what the governor is saying about lifting all these bans. You only are as safe as you want to be. All right. So good night, you all, and take care.